Hi, this is Suman Das Bhattamishra, Assistant Professor of Law at National Law University, Odisha, Cuttack, and today I am here to discuss a module on the law of domestic violence in India as part of your course in Substantive Criminal Law. Before we get into the objectives and the content of the module, let me first introduce you to the topic. The problem of domestic violence, like many other problems in Indian society, has perplexed and in fact shaken the entire country. The problem of domestic violence has been phenomenal, particularly because of associated social ills like dowry, matrimonial cruelty, etc. So, under this chapter and in this module, I will be teaching you how exactly the law pertaining to domestic violence proceeds in India. So, the objectives of this module are threefold. Firstly, to sensitize students to the problem of domestic violence and the law relating to the issue, to discuss important provisions of the Protection of Women and from Domestic Violence Act 2005, as well as Section 498A of the Indian Penal Code, to discuss significant judgments in the area of domestic violence and matrimonial cruelty. So, before we actually get into the legislation and the content of the legislation, which is the Protection of Women from Domestic Violence Act of 2005, let me introduce you to the prelude which was to the PWDVA, that is section 498A of the IPC. This section was introduced in the Indian Penal Code in the year 1983 by an amendment and was specially crafted for meeting the requirements of married women in their matrimonial homes. It was the very first manifestation of a law on domestic violence, although it had a very limited scope. The section does not really define cruelty, however, it has an explanation which states that matrimonial cruelty can be of two types, either physical or mental. The problem associated with section 498A is that it provides only for penal remedies. It does not address all problems and all forms of domestic violence and is applied only to married women, which means complicated relationships like relationships in the nature of a live-in relationship, etc., cannot be taken into consideration under section 498A. Now, when we talk of 498A, it is only pertinent on our part to look at the provisions under this section. So, section 498A under the Indian Penal Code talks about punitive provisions for the husband or the relatives of the husband who indulge in any form of cruelty that can endanger the life or the limb of the woman or can have an impact on her in the form of an emotional harassment by causing mental cruelty. So, this section obviously has its target as the husband or the relatives of the husband. The term relatives of the husband obviously connotes that the relatives would be persons who are connected either by consanguinity or by blood relationship. So, parents of the husband, sister or brother of the husband and other relatives of the husband come into the picture. But as per the Supreme Court pronouncement, friends of the husband are not really covered within the term relatives of the husband under section 498A. Section 498A of the Indian Penal Code also has a protective shield for women who have been victims of matrimonial cruelty. So, which means that a woman who has been subjected to matrimonial cruelty in her matrimonial home can approach the court to seek a remedy which is obviously penal in nature, because the section, as I said, one of the most important limitations of section 498A is that it does not provide for any penal remedies. It does not provide for any form of compensation, does not provide for any form of other civil remedy which a woman could have taken into cognizance. So, the only form of punishment which is provided is in the form of an imprisonment which can extend up to a period of 3 years. Now, this is a major problem because in civil law, having cases of 498A filed against a husband or the family of the husband is also a ground for divorce. So, for instance, while seeking a divorce under the Hindu Marriage Act and under section 13 of the Act, when we try to establish matrimonial cruelty, cases of 498A which have been frivolous, or in other words which haven't reached a conclusion wherein the husband has been convicted or the relatives of the husband have been convicted for the offence of matrimonial cruelty, is a sure shot ground for divorce which can follow. Now, the requirement of marriage, and marriage being the institution that it is, also needs to have some sort of civil arrangement which doesn't really take the husband or the relatives of the husband behind bars, but at the same time provides for some kind of remedy which is in between, or which can actually be used as a method of mediation or negotiation, and doesn't really have an impact on the breakdown of marriage. So, this is a very significant limitation of 498A, where we take issues in the matrimonial home to the bars of the prison. And another important limitation, as I already pointed out, is that all forms of domestic violence have not been addressed under section 498A. So, when we say all forms of domestic violence, I would mean that the term cruelty, which has been explained in section 498A, covers cruelty which is either physical or mental in nature, but doesn't look into those forms of cruelty which can be part of a day-to-day matrimonial life or a day-to-day married life, and which may be verbal, which may be emotional, which may be economic in nature. And of course, the other most important drawback of section 498A is that it has its application only to married women, which means some sort of marriage between the parties has to exist for the law to come into operation, and complicated relationships in the Indian scenario are not taken into consideration for addressing the problem of matrimonial cruelty. So, it presumes that cruelty between partners or intimate partner violence as a concept in itself will have its relevance only when marriage is in the picture. An exception to section 498A, however, has been the case of Reema Agarwal versus Anupam, which has a factual matrix which is very complicated in nature, and at the same time no one expected the court to deliver a judgment which would be in consonance with section 498A. So, Reema Agarwal was a victim of matrimonial cruelty. However, her situation was very special because she was the one who had married Anupam, having knowledge of the fact that he had already been married and had an existing spouse. The marriage between Anupam and his first wife had not been terminated. They were not staying in a judicially separated manner. However, Reema, who was completely in the loop of facts, decided to get married to Anupam. As fate would have it, Reema faced the problem of dowry harassment and matrimonial cruelty at her in-laws' place, where she accused Anupam as well as his relatives of having harassed her for dowry, and because she could not meet the demands of dowry made by their in-laws, Anupam used to physically harass her, and sometimes the abuse was also emotional in nature. So, one fine day when she was admitted in the hospital, she decided to take this case up under section 498A of the IPC. Now, as we know, section 498A presumes marriage as the fulcrum of application of this section. However, in this case, the court had taken a different opinion. Reema gathered the courage to approach the court despite the fact that she had a marriage which was not recognized in law as valid. Under the Hindu Marriage Act, a marriage with a person who has an existing spouse is considered to be a void marriage. So, the marriage being invalid, the marriage being void, the biggest question which came into the picture was, can we then hold the accused liable for the offence of matrimonial cruelty under section 498A of the IPC. The court made a very logical argument, and the major premise of this argument was that although matrimonial cruelty is based on the existence of marriage, it is not necessary for the marriage to be valid. What is necessary is that the marriage must be existing between parties. What form the marriage takes is not a question for us to decide upon. So, if the parties had been living together as husband and wife, and they shared or had decided to share responsibilities of marriage between each other, they decided to have rights and obligations towards each other because of the marriage, then it would be considered as a form of marriage. And yes, this is exactly where we have decided that matrimonial cruelty could have happened in this case, and legitimacy of the marriage or invalidity of the marriage cannot defeat the very purpose of section 498A. The court went further to state that the section 498A of the Indian Penal Code has the purpose of punishing those men who influence their women by or have an impact on their women by going for domestic violence or matrimonial cruelty. And the purpose of this section is greater than the relevance of the marriage which is in the picture. A man cannot use an invalid marriage to circumvent the provisions of section 498A. So, here we have the case of Reema Agarwal versus Anupam as a case which is very exceptional in nature, and as a case which has been a very progressive one, considering the fact that matrimony has always been the fulcrum of section 498A of the Indian Penal Code. Now, after section 498A, we now talk about a very important legislation which came into picture, the PWDVA, or the Protection of Women from Domestic Violence Act in the year 2005. Now, section 498A, as we discussed earlier, had its own complications, drawbacks and limitations. So, necessity demanded that we have a legislation which overcomes the problems that 498A posed and which is applied or has its application in areas where section 498A could not touch. So, in the year 2005, the Parliament came up with Protection of Women from Domestic Violence Act. The preamble of the 2005 legislation says that the Act has been designed to protect the constitutional rights of women. Now, if we look at the preamble of PWDVA very carefully, we would notice that the legislation has begun with the presumption that rights of men and women are not balanced in the constitutional country of India. Although the Indian Constitution came into force in the year 1950, even then we did not have and still do not have provisions of law which are equal in their application towards men and women. There have been many arguments about certain laws being biased towards men, and there have been feminist arguments about certain sets of laws which are needed in the country for equalizing the balance between men and women. It is with the objective of protecting the basic rights and dignity of women that the PWDVA had to come into picture in the year 2005. Now, as the preamble says, it is an act which has been designed to protect the constitutional rights of women, particularly those women who have been victims of intimate partner violence. In criminology, the idea of intimate partner violence suggests that it's a form of violence which can happen between two spouses or two partners, maybe live-in partners or a couple, where one of them affects the other, either physically injures the person or emotionally abuses the other person, or even in any other manner causes cruelty to the concerned person. Now, an important feature of the PWDVA 2005 is that civil remedies are also available under the legislation. So, this is where we have taken a step further, and this is where we have also tried to overcome a very basic limitation of section 498A. Because of its presence in the Indian Penal Code, the only way one could handle section 498A was to go for penal provisions. However, PWDVA 2005 decided to take a step further and came up with civil remedies. Section 3 of the PWDVA, or the Protection of Women from Domestic Violence Act 2005, states that various forms of violence have been covered under it. So, primarily 4 forms of domestic violence have been recognized under the PWVA. So, its scope is much broader than what we have under section 498A of the IPC. So, the forms of violence that we have covered are physical, emotional or verbal, economic and sexual form of domestic violence. So, when we say physical domestic violence, it means when one partner causes physical injury to the woman in question, she can be said to be a victim of domestic violence. Such injury may be actual, or the woman may also have been threatened with physical violence. Likewise, emotional violence includes the concept of verbal violence. So, verbal abuse wherein a woman is the victim of certain emotional abuse, in the sense that she is said harsh words by her in-laws. So, calling a woman by names, or injuring her emotions by calling names against her parents. This can qualify as emotional or verbal abuse, and it is a form of domestic violence which has been recognized under the PWDVA 2005. Likewise, a very new form of domestic violence which has been recognized under the PWDVA is the economic form of violence. So, when we say economic form of violence, it includes within its scope many things. So, for instance, when the husband denies to maintain the wife, or denies access or entry into the shared household, or when she is just thrown out of her matrimonial household, where she is not given the basic requirements of her life which she is entitled to by virtue of the matrimony that she shares with her husband, this qualifies as economic abuse. Followed by economic abuse, we also have in the picture sexual abuse. So, any kind of abuse wherein the woman has or is made to feel that her dignity has been compromised because of the sexual acts that she has been forced to indulge in, would amount as a sexual form of domestic violence. So, these are the 4 forms or varieties of domestic violence which have been addressed to under the PWDVA 2005. Followed by the things that we have already talked about, I think it is important for us also to take note of section 2F of the PWDVA 2005, wherein the term domestic relationship has been defined. So, when we say domestic relationship between 2 persons, we include all relationships which are by consanguinity or by marriage. And the most important thing about Domestic Violence Act is that it also takes into consideration live-in relationships for the purpose of defining whether a woman has been a victim of domestic violence or not. So, one live-in partner can actually bring up a case under the Domestic Violence Act 2005 for being a victim of domestic violence. So, this is one necessary feature and a very progressive feature of PWDVA 2005. Followed by this, I think we need to take a look also at chapter 3 of the PWDVA, which talks about the powers and duties of very important functionaries who have been created under the legislation and who have been designated such positions for the purpose of protecting the rights of victims of domestic violence. After that, under section 8, the term protection officers has been defined, and appointment of protection officers has also been talked about in the legislation. Section 5 talks about the duty of the protection officer whenever a case of domestic violence comes before him, his duty to inform the remedies which are available to the victim under the PWDVA 2005. Section 6 talks about the fact that the protection officer has the right to to request a shelter home to provide shelter to victims of domestic violence. A very unique feature of the legislation is the creation of officers called service providers. So, a company which has been registered under the Companies Act, or an organization which has been registered under the Societies Registration Act, all of these can come into the picture as service providers. And here under section 10 of the PWDVA 2005, a provision has been made for registration of any voluntary association as a service provider. These service providers have been created for the purpose of protecting women from domestic violence and for the purpose of extending remedies to them and making them aware of their remedies under the PWDVA 2005. Apart from that, the Act also talks about other functionaries who have been designated for the purpose of protecting rights of the victims of domestic violence. Followed by that, the legislation is also unique because it makes provisions for protection orders, residence orders, monetary reliefs, custody orders and compensation orders, all of which are remedies available to the woman for protecting her rights when she has been a victim of domestic violence. So, under section 19, a woman can approach the court and seek a residence order, an order which has been designed for restraining the respondent from either alienating or disposing of or renouncing rights in the shared household which they have been sharing, as in both the partners have been sharing, except with the permission of the magistrate. And under this section, the magistrate may also direct the respondent to secure an alternate accommodation if the woman has been victimized, or if the magistrate feels that the presence of the husband in the shared household may be more problematic for the woman. The respondent may also, or even his relatives, they may also be restrained from entering any part of the shared household under this section. Now, under section 19, the magistrate may also direct the respondent to not enter the premises of the household. Secondly, the provision for monetary reliefs is another important provision which has been there in the PWDVA 2005. Under this provision, which is captured in section 20 of the PWDVA, a fair and reasonable monetary relief may be provided to the victim for compensating for loss of earnings on account of domestic violence, for meeting medical expenses, or even for making up loss which has been caused due to destruction, damage or removal of property from the control of the aggrieved party. Now, this is a legislation, this provision has been to counter economic violence which has been captured as part of domestic violence in the Act. The types of monetary reliefs provided under section 20 are, however, not exhaustive. Then we have under section 21 custody orders. Now, a temporary custody order may be made the custody of a child may be given to the aggrieved party or any person making an application on behalf of the victim. Because custody, again at this point I must mention, is a major issue in matters relating to domestic violence. So, making provision under the PWDVA has only been pertinent. This was required under the legislation and has therefore been made. Then we have issues like compensation orders. This is again another relief which has been provided. The magistrate may make orders for providing compensation and damages to a victim of domestic violence on account of distress, on account of torture which has been caused by the respondent. Now, at this juncture, I would like to discuss a couple of cases with you which are pertaining to domestic violence under the legislation. So, in the case of Sukirt Kumar Verma and another versus the state of Rajasthan and another, the issue of monetary relief had come into the picture under section 20 of the PWDVA. The court made some important observations on the duty of a husband to financially provide for a wife, and the Delhi High Court initially had passed a judgment stating that a husband is under no obligation which is legal in nature or even moral for that matter to provide maintenance to a wife, and the Supreme Court had gone against or expressed disagreement with the observation of the Delhi High Court, and it is at this juncture that they had stated that the husband has a legal obligation to maintain his wife. Further, the Rajasthan High Court had also observed that under section 20, the idea has been to bring about economic parity between the husband and the wife, and where the wife has been denied of economic means, it is the husband's duty to provide monetary relief if she has been the victim of matrimonial violence or domestic violence under the Act. The same line of argument was also taken in Om Prakash versus State of Rajasthan and another, but in this case the Rajasthan High Court went a step ahead and said that a victim of domestic violence can have a claim against her husband for monetary relief or for compensation and maintenance, even if the husband is poor or invalid. So, being poor or being invalid or being physically challenged is not a ground on which monetary relief can be denied to a victim of domestic violence. So, as to conclude, the Protection of Women from Domestic Violence Act has certainly played a very big role in providing relief to women who have been victims of domestic violence. However, there have been roadblocks in the effective implementation of this act. So, for instance, a major roadblock has been in the very appointment of protection officers. Protection officers are the main office bearers under this act, and they are the chief instruments of implementing the act. The state government is vested with the responsibility of protecting women by appointing protection officers under the PWDVA of 2005. And because protection officers have not been appointed in many states across India, the implementation of PWDVA faces a major jolt. Now, apart from that, statistics also reveal that the cases of domestic violence which have come up lately, they are only tip of the iceberg. So, which means that there are many women who are victims of domestic violence, and their number is far greater on records, but they are not approaching courts for addressing problems of domestic violence. So, a more meaningful method of implementing the PWDVA has to be adopted. So, as to summarize quickly what we learned in the last few minutes, I would like to say that we need to emphasize on few points of domestic violence. First of all, it is a major social problem in India which has been part of many Indian homes for a very long time now. The first attempt to resolve this problem or to have a legislation to this effect was made in the year 1983. Section 498A was the section which was introduced by an amendment in 1983 and partly addressed the problem of domestic violence by talking about matrimonial cruelty. In the year 2005, the Protection of Women from Domestic Violence Act was passed, as Section 498A was found insufficient to deal with the massive problem of domestic violence. PWDVA 2005 followed a very broad approach towards defining the problem of domestic violence, and the objective of this legislation was to protect constitutional rights of women who have been victims of domestic violence. The Act also makes provisions for special officers like protection officers and service providers for the benefit of victims of domestic violence. PWDVA makes provisions for various types of remedies extending from residence orders, protection orders, custody orders, monetary reliefs for addressing the problem of domestic violence. For a more effective implementation of the PWDVA, the central government came up with the PWDVA rules in the year 2006. The Act, coupled with the rules, is the major instrument for addressing the problem of domestic violence in India. That's it. Thank you.